The Supreme Court decided that presidents are immune from almost all criminal prosecutions. Well, that would have been nice to know before we started all these criminal prosecutions of a certain former president. Yes, the decision in Trump versus United States, an aptly named case if there ever was one, has far-reaching implications. Trump is currently facing multiple criminal prosecutions. Will those prosecutions survive? He was already convicted in New York. Will that conviction stand? Well, I've got some bad news for you. Now, you might recall that the Supreme Court created a framework to decide whether an action by a president can be prosecuted after they leave office. The court created different rules depending on whether the action was an official act that was part of the core functions of the president, non-core but still an official act, and non-official acts. Now, core official acts are absolutely immune. Non-core official acts are at least presumptively immune, though possibly absolutely immune. We don't actually know. It wasn't decided in that case. And non-official acts are not immune and can be prosecuted. Now, the court doesn't provide a standard between core and non-core official acts. The only thing the court says is that, quote, at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. As we talked about in our last video on presidential immunity, that's barely a limit whatsoever. But in terms of distinguishing a president's official actions from his unofficial ones, the court says, quote, when the president acts pursuant to a constitutional and statutory authority, he takes official action to perform the functions of his office. The immunity we have recognized extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. And as we talked about in our last video on presidential immunity, that too is barely a limit. But on top of that, even when you're prosecuting a president for criminal conduct that is not an official act, you're not even allowed to use evidence of official acts to show motive for a crime. It's a complete evidentiary bar. So lawyers and judges are going to need to try to apply that framework to the ongoing prosecutions and conviction. How will that all shake out? Well, it's extremely messy, if not entirely unworkable. But let's start with the New York case. Trump was convicted of 34 felony counts of creating false business records to conceal hush money payments. The sentencing was scheduled for July, but it's now been pushed back to September because Trump has moved to set aside the jury's verdict based on the Supreme Court's ruling. Judge Merchan said that he will rule by September 18th. And according to a letter by his lawyers to Judge Merchan, before trial, Trump objected to several pieces of evidence based on the presidential immunity doctrine. Disputed evidence includes a 2018 filing with the Office of Government Ethics, OGE, witness testimony regarding events in the Oval Office, social media posts during President Trump's first term, the OGE form from March 2018, and toll records reflecting calls involving President Trump while he was in office in 2017. Now, the OGE forms are public records, and during the pretrial process, Trump challenged the admissibility of the OGE forms, quote, because the OGE regulates executive branch personnel. President Trump's communications with the OGE during his first term were also official acts and therefore also inadmissible at trial. But Chief Justice Roberts explained in Trump versus US, quote, of course the prosecutor may point to the public record to show the fact that the president performed the official act. This was in response to Justice Barrett's concurring opinion where she pointed out that if you don't allow evidence of official acts, you basically make bribery and a whole bunch of other crimes completely impossible to prosecute. And many have pointed out that Justice Roberts saying that you can point to the public record actually conflicts with the bar on admission of official acts as evidence. So who knows what he actually meant by that in the majority opinion. These records disclose payment from Trump to Cohen, but completing the form was arguably an official act by a president that arguably Trump can't be charged for. But it's also a public record, and it's something that the court could take judicial notice of. Question mark? This is just the tip of the iceberg of how unworkable all of this is. But the conspiracy to pay hush money to Stormy Daniels to cover up an affair, which required falsifying business records, started before Trump was president. Most of Trump's acts happened before he was president, but not everything. So what about his conversations with Hope Hicks, Michael Cohen, and the Trump Organization officials that happened in the White House? Arguably, they aren't within the outer perimeter of a president's official duties, since those acts were all about following through on reimbursing Cohen for paying off Daniels before the election? Maybe? I mean, the case was about Trump falsifying Trump Organization business records. And the president's duties don't include acts maintaining a private business. But on the other hand, Trump was talking to his political advisors in the White House, and the Supreme Court did say that conversations with advisors are presumptively official. This is a mess. But it wouldn't be a great surprise if the appeals court eventually rules that this evidence is not off limits and could have been used. New York courts have already ruled on presidential immunity before the case went to trial. Trump tried to remove his case to federal court, but the federal court said that the hush money scheme was personal. Quote, hush money paid to an adult film star is not related to a president's official acts. It does not reflect in any way the color of the president's official duties. The court also concluded that Trump had, quote, expressly waived any argument premised on a theory of absolute presidential immunity. Trump then dropped that appeal, so it's likely that he's precluded from making the claim again, although he'll probably do it anyway. And all this was decided before the Trump versus US opinion came down, so everything's sort of up for grabs. But as we're seeing, a lot of this depends on how you characterize it and at what level of generality. Surely every president will need to deal with their own personal finances. Not every president sells their peanut farm. And additionally, Trump filed a pretrial motion to exclude certain tweets and interviews from trial because those were official acts for which he is constitutionally immune. Trump asserted that the tweets he made about Michael Cohen and the hush money payments were official acts because he used his official Twitter account, which was, he claims, quote, an official communications channel during his presidency. Here are the tweets. One is about Michael Cohen flipping or not flipping. One is about Michael Cohen's retainer. One is about Paul Manafort not breaking, like Michael Cohen. And he also called into Fox and Friends on several occasions, talking about Cohen's legal work and Obama's massive campaign violations. The defense argued that, quote, President Trump's social media posts and public statements, while acting as president and viewed in context, fell within the outer perimeter of his presidential duty, to which communicating with the public on matters of public concern was central. But was it official? Well, before Trump versus US, it would have been way too simplistic to say that if the president did a thing while on US government property, it's an official act. But now it might be. If the Supreme Court decides that the locus of an act is an important factor in determining its character, some of these statements were made on Air Force One. And as for the tweets, Trump argued that they were official acts because Trump's Twitter account is one of the White House's main vehicles for conducting official business. Now, originally, Judge Merchan denied Trump's motion because it was untimely. Quote, the defendant had ample notice that the people were in possession of and intended to use the various statements allegedly made by defendant on social media, in public, and in various interviews. He was also well aware that the defense of presidential immunity, even if unsuccessful, might be available to him. For example, and as discussed more fully below, defendant fully briefed the issue of presidential immunity in his motion to dismiss. He also demonstrated awareness that the defense was available to him when he attempted to remove the instant matter to federal court on May 4th, 2023. Nonetheless, defendant chose not to raise the defense of presidential immunity until well past the 45-day period provided by statute. And of course, when the federal court considered Trump's motion for removal to federal court, it also found that his acts were not entitled to immunity. Quote, Trump conceded in his notice that he hired Cohen to attend to his private matters. Cohen's invoices and their associated records were maintained by the Trump Organization, a private enterprise, in New York City, not in Washington, D.C., as official records of the president. Trump paid Cohen from private funds, and the payments did not depend on any presidential power for their authorization. Trump offered no evidence regarding what Cohen did as Trump's personal attorney, neither the constitutional prohibition barring the president from taking compensation, beyond that fixed by the Congress, nor the constitutional obligation to take care to execute laws, converts the president's private acts into acts under the color of his office. And that certainly made sense in the before times. We'll see if that logic still applies. But how will Trump fare on appeal? Well, it depends on how the Court of Appeals construes the excluded evidence. If a trial court makes evidentiary rulings which deny a person's fundamental right to a fair trial, an appellate court must reverse the judgment and grant a new trial, without regard to any evaluation as to whether the errors contribute to the result. Fundamental errors are situations like a person being denied the right to assistance of counsel, denial of due process, or denied the right to present witnesses. It seems like those weren't present in Trump's case. And Trump argues that the introduction of any evidence covered by immunity is necessarily irreparable harm. But most trial errors end up being considered harmless error, which is an error by a trial judge in the conduct of a trial that an appellate court finds was not damaging enough to the appealing party's right to a fair trial to justify reversing the verdict. In New York, they call this non-constitutional legal error. Quote, the standard for non-constitutional error, which is governed solely by state law, requires reversal if the properly admitted evidence was not overwhelming and there is a significant probability that the jury would have acquitted the defendant had it not been for the error or errors which occurred. In practice, this means that the admission of improper evidence is considered harmless if the outcome probably would have been the same, even if the evidence had been excluded. The appeals court will consider whether the included evidence would have been a substantial influence in producing a different result. And generally, the stronger the evidence of a person's guilt, the more likely the court is to find substantial error. Now, appellate courts and the Supreme Court usually love findings of harmless error. They are loath to disturb convictions. Now, that carries its own issues that I won't get into at the moment, but given the breadth of the Trump versus US decision, it's entirely likely that they find the evidence was covered by immunity, and of course, it's not harmless error, and thus they overturn the conviction. Okay, but what about the Fulton County prosecution for interference with the election in Georgia? Well, as lawyer Ken White put it, can you really torpedo something that has already sunk? Yeah, this one was not moving forward for a long time following the fallout from the Fani Willis scandal, but if this prosecution ever does move forward, then Justice Amy Coney Barrett's concurring opinion concluded the acts alleged in the Georgia case were not official. Quote, the president has no authority over state legislatures or their leadership, so it's hard to see how prosecuting him for crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on executive power, including asking Secretary of State Raffensperger to find 12,000 votes, just enough to win. The Georgia case also involves Trump participating in a scheme to appoint false electors, and Barrett concluded, quote, in short, a president has no legal authority and thus no official capacity to influence how the states appoint their electors. I see no plausible argument for barring prosecution of that alleged conduct. So that's the argument for why these acts would not be considered official or immune. However, Trump also has strong arguments that his conduct is official. Right off the bat, the majority did not join in Justice Barrett's concurring opinion, so one might surmise that they don't agree with her in this respect. And again, it all depends on how you characterize the acts and at what level of specificity. Although interacting with state officials isn't a core power like dealing with the Attorney General, the basic act of communicating with state legislators and other officials might be considered within the scope of the official duties contemplated by the Supreme Court's decision. And I'm sure Trump will argue that ensuring election integrity is a key role of the executive branch. Investigating and prosecuting election fraud is an important role for the DOJ, and that he was taking care that the federal election laws were being followed. And though Justice Barrett's opinion was not joined by the majority of justices, prosecutors, I'm sure, will cite to it to contend that courts should construe the official duties narrowly. They can point out that Justice Barrett joined the majority opinion on everything except for not being able to use evidence of official acts in prosecution of an unofficial crime, and therefore she must believe that the majority opinion leaves room for that conclusion. But Georgia courts have already grappled with some aspects of the case because Mark Meadows and Jeffrey Clark, both co-defendants along with Trump, tried to remove the state case to federal court on the basis that the charges implicate actions that they took as part of their duties as federal officers. And the judge held a mini-trial that explored what Meadows and Clark did in their jobs as chief of staff and the Department of Justice lawyer, and how that impacted the charges against them. And Georgia prosecutors showed that Meadows and Clark were acting outside of their scope of their official duties. The 11th Circuit eventually affirmed the lower court's decision that Meadows was acting outside of the scope of his job when he participated in Trump's perfect call pressuring Georgia Secretary of State Brad Raffensperger to find him the votes, and Clark was also unsuccessful at removing the case to federal court. But at the same time, the Supreme Court already said that the interactions with DOJ officials, including Jeff Clark, were very cool and very legal. The court said that all of that evidence about Trump meeting with the Attorney General and others in the Justice Department was off limits because it involved one of the president's core powers. Quote, the president may discuss potential investigations and prosecutions with his Attorney General and other Justice Department officials to carry out his constitutional duty to take care that the laws be faithfully executed. So that will throw up huge roadblocks in the prosecution going forward. But the Georgia case is currently stayed while the defendants challenge the trial court's ruling that Fani Willis is allowed to remain on the case, and the Georgia Supreme Court will hear oral arguments on October 4th, with a decision to come next spring, long after the election. Now, if you tried to overturn an election, you'd probably want a good lawyer, but if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those notifications saying that your social security number was leaked, and you're like, why do you even have my social security number? You shouldn't have it anymore. Or basically anything else, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your chances of a good recovery. So just click on the link in the description or call the number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click on the link below. But what about the DC prosecution? Well, we already know what the Supreme Court had to say about aspects of the DC case, and it's not great news for Jack Smith. The majority opinion sorted the allegations about Trump into several categories: actions involving the Justice Department, actions involving his advisors, actions involving the vice president, and actions involving his speech. In many cases, they said the acts were immune. So now Judge Chutkan needs to go through every allegation in the indictment and apply this framework of presidential immunity. It's currently not clear whether Judge Chutkan will need to hold evidentiary hearings or whether she can just make decisions as a matter of law looking only to the allegations in the indictment. But as I already mentioned, the Supreme Court said that the meetings and discussions with the Justice Department officials is completely off the table. And that's alarming because Trump was meeting with the Justice Department because he wanted them to make up a reason to declare the election null and void. He tried to use the DOJ to create a sham investigation and potentially sham prosecutions. But we can't talk about the president's motive with respect to the Department of Justice, and we can't even use the evidence of those discussions. Apparently, because Trump has the power to ensure that the laws are being faithfully executed, it doesn't matter that he wanted to use the power to overthrow the election results. The Supreme Court explicitly says that this is a core function and is off limits. And as I mentioned in the last video on presidential immunity, this is probably one of the reddest of red flags in the opinion because it gives Trump the okay to use the Justice Department to wage war on all of his critics, create sham investigations, and even have the DOJ falsify evidence against his rivals. And those actions cannot ever be challenged, or at least he can't be prosecuted for it. But what about his communications with Mike Pence? Well, the majority opinion acknowledges that the vice president's role in certifying the election is not an executive branch function, and the president plays no direct constitutional or statutory role in counting electoral votes. So one might conclude that Trump trying to coerce Mike Pence not to certify the election is also outside of his official acts. But no, the majority says that if a president knows he could be prosecuted for trying to get his VP to overthrow the election, it would interfere with their ability to work together in the future. Quote, when the Senate is closely divided, for instance, the vice president's tie-breaking vote may be crucial for confirming the president's nominees and passing laws that align with the president's policies. Applying a criminal prohibition to the president's conversations discussing such matters with the vice president, even though they concern his role as president of the Senate, may well hinder the president's ability to perform his constitutional functions. But the court did not rule that the conduct related to Pence fell within the president's official duties. It remanded that issue back to the district court. And the other strange thing about the Supreme Court's opinion is that it would seemingly knock out all of the evidence that Trump knew he lost the election. The DC indictment is full of conversations Trump had with advisors and officials. Jack Smith cited those conversations to show that Trump knew he lost and intended to break the law with a fake elector scheme. But if all evidence of official acts is inadmissible, it's not clear how Smith can prove Trump's state of mind. Oh, and guess what? The court did not fast-track the remand, which means that Judge Chuck Kin can't do anything until August 2nd. And you can bet that if she rules against Trump on any of these categories, you can count on the Supreme Court to review it sometime in 2026. So all that means that Jack Smith's DC case is not going to trial before the election, and probably not for years, if at all. Now, I previously recorded an entire section about the intricacies of the Florida prosecution and how it too would have entailed thorny questions of presidential immunity, and that the whole prosecution was in jeopardy. And I promise this part is true. There was an entire section about how it seemed like Justice Thomas wrote his concurrence in Trump versus US specifically for Judge Cannon to run with it and claim that Jack Smith was illegally appointed. And I was like, don't be surprised if she dismisses everything based on that concurrence, ha ha ha. And then she actually dismissed the entire case based on Thomas's concurrence. It's an insane decision that we'll cover in its own video. But for now, just know that to get to her desired outcome, she ignores a Supreme Court case that's directly on point, a DC Circuit case that's directly on point, and a statute that very clearly gives the Attorney General authority to appoint Smith. So that's a completely insane decision that will obviously get appealed. And that's reflected in the news reporting too. What's interesting is that Judge Cannon's dismissing the documents case has been covered extensively by over 300 news outlets. 29% of the reporting is coming from the left, and 18% is coming from the right. But if you compare the headlines, you'll start to see some interesting framing emerge. On the left, you have an outlet calling the decision stunning, and on the right, we sometimes see outlets bizarrely contextualizing the decision as coming hours after the Trump assassination attempt. So if you read the left-leaning sources first, you might think that Judge Cannon's decision was erroneous and the result of political bias. I can't imagine why, as with the Mother Jones headline. And if you read the right-leaning sources, you might see the prosecution as one element of an unfair, broader conspiracy to silence Trump. Now, this is all possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite tools is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, which could be run by total nutjobs. And I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. It helps explain why we often talk past each other and why some people seem hyper-focused on what seems like nonsense, often because some random blog went viral among certain groups of people. And that's why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off of the Ground News Vantage subscription by clicking on the link that's on screen or down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.